you a seat. Grab yourself a cup of joe and put up your feet. Let's talk about the latest news and all about true crime. We can make a difference if we put in the time. Good evening, come and find you a seat. Grab yourself a cup of joe and put up your feet. Let's talk about the latest news and all about true crime. We can make a difference if we put in the time. Oh, we can make a difference if we put in the time. Good evening, come and find you a seat. Grab yourself a cup of joe and put up your feet. Let's talk about the latest news and all about true crime. We can make a difference if we put in the time. Good evening.
Good evening, everybody. Welcome in. This is Joe Schmo's channel. I am Joe Schmo. I'm just an everyday Joe Schmo with an interest in true crime, history, and mysteries. And of course, today we're talking about true crime. And some things happened in court today. So I was at the courthouse today, Maricopa County Superior Court, for jury selection in Lori's trial. I didn't go yesterday, and I'm kind of mad at myself that I didn't go yesterday because they held a hearing on Lori's motion to dismiss Judge Boreski for bias. Nobody from the media got there, though, because he assigned it to another judge. We'll take a look at that. I got a copy of that video with better audio. I think Fox 10, for some reason, that video is really blurry on Fox 10 and East Idaho News and all the other ones. But the audio is better on Fox 10 than the one we watched last night. So at the end, we'll go over those documents. We got minute entries that came down today. So we'll go over those minute entries. But first, we're probably going to have to talk about what happened in court today, because there were a couple of surprising things, and there were a bunch of disappointed people, and there's a bunch of speculation out there about why what happened. And I'm not going to speculate myself, but I will talk about what other people are speculating about, because I heard the judge's words, to Lori directly. And so I can tell you what the judge said to Lori. Hey, Salty, welcome in. Carolina, welcome in. Good to see you. Yeah, so I'm up here by myself right now, which is just fine. I can take my time and pay more attention to chat. Sometimes it's better to have somebody up here with me like Salty or Kresha to kind of bounce things off of. But I'm telling the story of what happened today. And then we're going to talk about what happened yesterday, which is pretty much unrelated to what happened today, but is very much related to what's going to happen next week with all of these jurors in here. Deanna, you're already stirring the pot. You're already stirring the pot. I haven't even got there yet, and you're stirring the pot. Oh my. Hold on a second here. I gotta check something. There we go. That's better. Thank you, Beach Bum. That is a picture that I took myself. That is a picture I took myself when we were standing in line to get into court for the last trial today. So we'll talk about that first. No, you know what we're going to talk about first. So something completely unrelated, but news just came down. That kind of makes me sad, but isn't totally unexpected. Y'all are going to think I'm a nerd, but one of my favorite television shows is MASH. And Loretta Swit was one of my favorite actresses on that. So I'm just going to play a quick 25-second clip notification that she passed away. She was one of the anchor characters on that show. Like, she was there from the very beginning to the very end. She was one of the few characters that was there from the beginning to the end. Yeah, Hot Lips.
Breaking news.
Wait. Yep, we got it. Okay, we're sharing. Good deal.
Hollywood mourning the loss of beloved actress Loretta Swit. She was best known for her iconic role as Major Margaret Hot Lips Houlihan on the TV series MASH. Swit passed away today at her home in New York City. She starred in the groundbreaking series for 11 seasons, earning 2 Emmy Awards and becoming a television legend. Fans remember her for bringing strength, humor, and heart to one of TV's most enduring characters. Swit was 87.
We're not going to play that one yet. So yeah, Hot Lips was one of my favorite characters. And she started out in that role as someone that was unlikable, and she completely turned that around by the time we got to the end of the show. She was very lovable, endearing character, and yeah, so rest in peace, Hot Lips. So now we can get to what happened today. I'm just going to tell it like a story. So Trace and I carpooled again together, and we got there just a few minutes before the doors opened. We didn't go really super early this time because it's jury selection, and we didn't anticipate a whole lot of people being there, and there wasn't anybody in line. It's 7:30, and we got up and sat down and waited until 10:30 for court to start. Yeah, well, it was sad. It was sad. That very last episode of MASH was, like, at that time, maybe the most watched sitcom television show ever. The final episode of that, Farewell and Amen, or whatever it was called. Yeah, we were forced to watch it. I kind of was too, but it grew on me over time. And then when I became an adult, my taste completely changed. My taste, especially for MASH. So it's my morning go-to. So they show like 4 or 5 episodes back to back to back on TV Land almost every morning. So as I'm getting my day started and I'm working on projects, I just have that playing in the background. And I know for a fact I've watched every single episode of MASH at least once, and I've probably seen some episodes like in the 30 or 40 time range. Just because, I mean, there's 11, 12 seasons of it. And they replay them over and over and over again. And that's my background while I'm working on projects in the morning. So Trace and I got to court, got inside, got up to the 5th floor, got our seats. Security is nowhere to be found. They're kind of wandering around looking for their signs, because they had these signs that said media stages here, public stages here, and they couldn't find them this morning, and they still hadn't found it by the time we left. They did have the little, like, movie theater queue ropes set up for overflow crowds. And we just waited until we got into court. And then, so the morning session of court, the jurors weren't in there yet. So there was plenty of seating for everybody. And they had 25 new walk-in questionnaires to go over. So they already had gone through the 300 other questionnaires, and they had whittled it down to 66 jurors out of the jury pool. So in other words, they struck everybody but those 66. So they went through the 25 questionnaires this morning. And the most common factors for striking them. Wait, did I write that on the previous page? They couldn't read and write or understand the English language very well. They had hardships due to finding childcare. They had hardships due to vacations. They had health hardships. I mean, there were a lot of hardships that were listed. And so they ended up, out of the 25, they only kept 2 jurors out of the 25 new questionnaires from the walk-ins today. So they released the other 23 from down in the jury room. I think that's down on the first floor. There is a huge jury room down on the first floor. So those 23 got to go. Susie, yeah, do you know what the name of that theme song is? Like, when I first found that out and what the lyrics are to that theme song, it's about suicide. The theme song to MASH is about suicide. So it's an interesting trivia fact that I've known for a while. All right. So anyway, they dismissed 23 of the 25 from the new questionnaires. They add those 2 to the 66. So now we're at 68 people in the jury pool for today. Judge lets us out. It's about 10:45 at that point. So that morning session only lasted like 45 minutes. So then we get a long lunch break. We come out immediately and get in line for the afternoon break because that's what they made us do in the last trial. So we're kind of following the rules from the last trial and also trying to all be adults and not cut in line. But there was no court security staff there to have any type of rules today, which was kind of interesting and weird, but not that, because there was apparently another huge hearing on the 6th floor. We're on the 5th floor, and that required a lot of resources from court security today. So they couldn't come down and help us with jury selection. And I talked to the one guy, Sergeant, I can't remember his name. I have to look back in my notes, but I said, it's probably not going to be real crazy today because it's just jury selection. And he agreed. So they probably consciously made that determination. Heather Rose, hi, welcome in. Welcome in, Tammy and Virginia and Zonia. Hey, everybody, welcome in. Talking about today in court for Lori's selection day. Oh, if you have questions, Heather, if you have questions, put some big question marks or something around it. And if it's congruent with what we're talking about right now, I'll go ahead and talk about it now. Otherwise, we'll save them and get to them at the end. As we can. So the morning session was over. We had a long lunch break and a lot of people just left. Nate left. Justin Lum left. Lauren and her producer left. And they're like, can you watch our stuff? I'm like, yeah, we'll watch your stuff. And in another courtroom, at the other end of the 5th floor, apparently they were impaneling a grand jury. And in the middle of our lunch break, a little bit after 11 o'clock, they gave them a 15-minute break. And the entire 5th floor was flooded with grand jurors. There are at least 50 of them. There may have been 60, may have been 70, probably not 70, but probably in the 50 range. So it felt really crowded, and they wandered all over the 5th floor, including where we were sitting. And I'm like, who are they being impaneled for? What's this trial about? Or what's the grand jury about? It's not a trial, it's a grand jury. But the stuff that was left behind probably was a good idea to have us keeping an eye on that, just because there's people everywhere. Butterfly, welcome in. Welcome. So anyway, during our lunch break, the grand jurors from another courtroom flooded the entire 5th floor, but it was only for 15 minutes. So they went back into their their grand jury impanelment. And then at 1:30, we all started lining up to go in the courtroom, and the Judge Bereski's courtroom manager, she is an amazingly capable human being. Like, she said, she came out of the courtroom and she said, "We can't let y'all in yet. I've got to bring the jury up here." So we're standing around for a while, and then the elevator. So there are 6 elevators, and the elevator doors start popping open, and jurors start coming out, and they assemble on the opposite side of the courtroom, or opposite side of the courthouse from us. They assemble on the south side. We're on the north side. And they're all wearing their little juror pins or stickers or whatever it is. They give them their bright green stickers that identify them as jurors. In other words, don't talk to these people, and they're not supposed to talk to you. And you probably shouldn't talk about the case in front of them. That would be a good idea. Even if you don't know if they're jurors for this particular case, which we knew these were, obviously, because they're all coming up out of the elevator to the 5th floor. She gets them all in order, 1 through 80 something. So she skipped some numbers in there. So she numbered them 1 through 80 something, but there were they ended up only being 65, because 3 of the jurors that were not struck yesterday didn't show up today. So they were included in the juror panel in that 66, and then 68. And then we find out towards the end of the hearing that they didn't show up. 3 just didn't show up. So they said they were going to try and contact them and get them to come in Monday. Yeah, Virginia Little, she doesn't look horrible. Like, if I'm sitting on the jury, I'm not looking at her, and I've never seen her before. I haven't researched the case, which has to be the case if you're on the jury. I'm not looking at her and going, "Oh, she looks horrible." They let her come in street clothes today. She was wearing her black jumpsuit with a lavender blouse. But you could definitely see like a little square thing on her back underneath her suit coat that I paid attention to this time, which is obviously the rack belt for security and protection. So the courtroom assistant gets all the jurors lined up in order. She's so awesome at her job. Brings them over in front of us. I'm like telling all these, so we're like lined up right in front of the doors to get in. And I'm like, all right, maybe we should move our line back away from the jury just a little bit. So we moved our line away from the jury just a little bit, and they go in. Takes a little bit to get all 65 of them in there. So 18 of them get seated in the jury box, and then the other 50 some of them get seated in the gallery with us when we file in. So last time during jury selection, and well, maybe it wasn't jury selection, maybe it was just the trial, court security would come out and say, "Okay, we're going to file in this particular order, whatever order you guys had arranged yourselves in." This time there was no, he just stuck his head out the door, and it wasn't even court security. It was the other like courtroom assistant, the male courtroom assistant that helps with stuff. And he just stuck his head out the courtroom doors and goes, "Okay, anybody that's interested, come in here now." And we're like, "What? Wait, no, we had an order established. Like we are organized ourselves." Yes, Susie, I was looking for the rack belt, and there was like a rectangle, like a decent sized rectangle, like the size of a notebook, on her back. So I wonder if that's like the battery pack that would electrocute her, or not electrocute, would shock her. I'm jumping the gun here. I don't. So she got the death penalty taken off in Idaho, and she doesn't have the death penalty option here. So electrocution is a little strong. She would be shocked. Incapacitated. What punishment is Trina case seeking? I believe the penalty for this is the same as the last one, which is 25 years to life. I believe. Oh, she's going to get zapped if she gets out of line. And she was, so overall impressions today, So when we went through the morning session, they pull up the juror questionnaires on their computer. So the defense has their computers with the questionnaires. The state has their computers, their monitors with the questionnaires. We're talking about jury number, 305 right now. And in paragraph A, it looks like this might be a hardship. So we're going to dismiss juror 30, or we're going to excuse juror 305, or, omit him or strike him or whatever word they used. They used multiple words. I was looking for her rack belt. I was looking for obvious signs of it. And we know that she complained about that in a motion from the last one, in her motion for a new trial. And the judge is like, and she's like, did you poll the jury to see if that little piece of my belt hanging out affected them? And judge was like, did you ask me to poll them? I don't believe anybody asked for them to be polled. So you gotta wonder. You gotta wonder if the judge gets tired of that, because it looked like he was in the last hearing, like he's just over her. I want to go back and look at that hearing again too after we get through all of this, after I get through my story of the day, Joe's story in court. Is Trace on the case in here now? Yes. Hey, Trace. My courtroom buddy. My other eyes. My second set of eyes in the courtroom. So we're in lunch, or after lunch session now. The jury's in the court. He lets the media and the public in. We have limited seating because there are 75 seats and like 50 of those are used up by the jurors. So we've only got like somewhere between 15 and 20 seats for the media and public. I think we all got in. I don't think anybody got turned away, but I was like first or second in line, so I got my seat. The judge goes, so we're not going to be able to complete jury selection today. Something has come up. So, how was it that he phrased it? Unforeseeable circumstances. And he said, through nobody's fault, just unforeseeable circumstances, we're not going to be able to complete jury selection today. And I'm like, what does that mean? Does that mean we're going to get through part of it? Does that mean we're going to get through 10% of it, 20%, 50%, 75%? But he realizes this is a huge jury pool. No, it wasn't that. Unforeseeable circumstances. And then he says to the jury, to all the jurors, who will not be able to make it here Monday? Now, keep in mind that Monday was supposed to be a regular day of trial anyway. So every single one of those jurors should have been expecting to come back Monday. Every single one. But there were it felt like 20 of them. So we ended up with 50, 55-ish. So 68 minus 3 is 65. It may have been 10 or 12, I guess. It felt like about 20 jurors raised their cards. And so the judge goes through one by one. Yeah, we won't go through the rest of those lyrics in that song. Yeah. So one by one, he asked the jurors, okay, so why won't you be able to be here on Monday? And I have the laundry list here. So since they filled out their forms, apparently, their questionnaires, apparently some of them have new jobs. One of them has a new apartment that she has to move into on Monday. No other day is possible. It's got to be on Monday that she moves into her new apartment. One of them has a new illness. She was in the ER over the weekend, so obviously excusable. One of them has a new project rolling out on Monday. And one of them has a new trip planned for during the trial. So, and this was almost all women. There were out of these 10 to 12 jurors that all raised their hand, raised their card, it was almost all women. There were 2 men, and one of those men has a, we'll get to in a second, because it wasn't a conflict with Monday. It was a conflict with the entire schedule next week. So then next the judge asks, since we're having to delay this today and we're going to have to do jury selection on Monday, we may have to push the trial back till Friday. And I know when we sent out the questionnaires, we said Friday would be dark. Lori doesn't want Friday to be dark, apparently. He said, how many people have a conflict with Friday? And I think only the one male, the one guy that was all the way down at the end of the jury box raised his hand. It was juror number 2. And judge says, so what do you have planned on Friday? And he said, well, I had a camping trip planned for a while. And judge says, well, when are you going to be gone on this camping trip? And he said, well, I'm supposed to leave Friday morning and come back Sunday afternoon. And then judge says, okay, thank you. And he gives them, he asked them again, and he said, not again. He asked them for the first time since they were in there. I don't know if he asked them down in their other room that they were in, because I know he goes down and talks to them before he brings them up for the jury selection portion of it. But he says, so at any time, but especially since you filled out your juror questionnaire, have you researched the case or any parties in the case? And not a single person raised their card. Not a single one out of all of those 60 some that were in the courtroom. So they're being good little boys and girls, for sure. So then they talk about, oh, I said about 12, right? It was 13. Because I counted them when he dismisses the jurors and he says, okay, I need you to go out and wait outside of the courtroom right now. Just go down to the end of the, to the south end of the waiting area outside, and we'll talk about this. So Trina K said, let's just take all 13 of those that said they can't come back in Monday, and let's just strike them now. Let's just eliminate them now from the jury pool. Like even if it doesn't sound like a valid excuse, even if they should have included it on a juror questionnaire before and they didn't, and they're coming up with something now, she says we have plenty of jurors in the jury pool, especially if those 3 didn't come in today, we can get them to come in Monday. She said we'll have 50 something jurors on Monday, and that's exactly what they had in the last trial, and they got that done in 3 hours. So yeah, that was the interesting part of that about the jury selection. So the judge tells his assistant, go out and tell those 13 jurors that they can be dismissed, and then tell everybody else they got to be back at 10 something on Monday morning. So that's the plan. They didn't get into any group voir dire. They didn't get into any individual voir dire, which is what they did in 3 hours on the first trial. So if they start at 10 o'clock, 3 hours would be 1 o'clock, and there's like a 15-minute break in there, but they had that in the first one too. But judge said, if we get through the jury selection, if we get the jury seated by 3 o'clock on Monday, he said, I plan to have opening arguments on Monday afternoon. And then he said to Lori, and I'm going to try and get as verbatim as I can because I was sitting right there and a lot of people have kind of like misheard what he said. He said to Lori, I understand that people get quarantined in the jail sometimes. He might have said a lot. He didn't say a lot. He said, I understand people get quarantined in the jail. And he said, if you think you will not be able to make court on Monday, you need to tell your team as soon as possible. He didn't say anything about her being sick. He didn't say specifically that she was the one being quarantined. And he didn't say anything like, well, if you don't feel up to it on Monday. He said, if you don't think you will be able to make it to court on Monday, tell your team as soon as possible. Virginia, that's a good question. So as soon as that happened, I stood up, and Nate Eaton and Justin Lund were sitting right behind me. They were in the back row. I was in the next to the back row, and I kind of whispered to Nate because we were all kind of still talking in hushed voices. So I kept my voice low, but it was still after the court was recessed, so we could have talked louder probably. But I just was like, Nate, why would he specifically mention being quarantined in the jail? Is she maybe sick? And so I stayed there and I tweeted a few more things. I tweeted an update while I was standing in the courtroom. Other people were leaving the courtroom. Trace and I were two of the last ones out of it, besides the legal teams. But when I come out, people are already saying things like, she probably has COVID, or she has this or that. And I'm like, speculation is running rampant. We don't, at this point, I don't know that we know what it is. Butterfly. That's the comment of the night so far. Oh my gosh. That's hilarious. Yeah. Yep. But Trace noticed, and I kind of subconsciously noticed, and looking back now, I can remember seeing it. But Trace noticed that when they said all rise for the jury and then all rise for the judge, she did not rise. So if she's like, I didn't get my homework done, I don't want to go to school today type of sick, that would be one of those symptoms. If she really is sick, that could be one of those symptoms that she's not strong enough to walk out. So if you remember one of her motions that Judge Boreski granted, was for her to be able to meet with her defense team during breaks. So we had a really long lunch break this time, and her defense team, it looks like, did meet with her at the beginning of the lunch break because they were late to get to their little office where they actually have their lunch. So they probably met with her for a few minutes. But then like maybe an hour later, there was one of the court security guys that went over to that defense room, and I've never seen them go in while defense counsel is in there, and he went in and talked to them for a little bit. So I wonder now, looking back, if he was telling them she's not feeling well, because she seemed to be okay in the morning session. Like, she walked right in, she just strode in her pantsuit and her rack belt, and she seemed to be okay. I'm pretty sure she was rising for the judge in the first one, because she comes in before he does every time. He waits until she's seated before he comes in. It's usually within a minute or two of each other. So, yes, it was all speculation. There is a lot of speculation going on right now. There was speculation about what that huge case was above us, whether it was one of the Gilbert goons pleading out. I hope it was that type of a hearing, whatever case it was, that it was just like a plea hearing and a sentencing, so we can get at least a little bit of court security staff back down there to maintain order and make people follow the damn rules. People always got to be trying to break the rules and cut in line. And it's funny because that one security guy I mentioned earlier, and he may be the head of all security. He may not be. I get the feeling that he is based on the people he talks to. But he's like, hey, y'all are adults. Y'all know what order you showed up here. Just act like adults. And I'm like, you're asking way too much of true crime fans coming to watch a Lori Daybell trial. You're asking way too much. People got bent out of shape in Delphi. People cut in line in Delphi. They didn't do any kind of a real system. It was just like, run out of the courtroom and get in line as fast as you can and hope you get a seat. Which is why I didn't go to every single day of that trial, because, well, that and getting up at 3:30 in the morning. Oh my gosh. Well, that's honestly what I thought when she had the rack belt incident earlier. I thought she had to have like an emergency bathroom break. That's what I thought happened in the first trial. But come to find out, she had a piece of her belt hanging out the back of her jacket, her suit coat, whatever you want to call it, blazer. And she didn't want the jury to see it. So she got to go tuck it in and come back. It wasn't a bathroom emergency. Not that time. But she was playing the part of being sick. She was playing it. And so we all got let out of court way early today, which is why I can do this live early today. Instead of at 9 o'clock, we start at 8 o'clock Eastern. Oh, Karen. That's something Homer Simpson would do. Or Cartman from South Park. Like, that's, yeah. I don't think she has the fortitude for that. She'd like, oh, I can't do it. Okay, so we did have 2 new court documents come down this morning while we're waiting to get into court. They are just the minute entries from yesterday, so there's nothing new and shocking, but we can still take a quick look at them. Yeah, that's Beach Bum. That's one of the speculations out there. How much can she stall though? Because if she's sick and she's really sick, there are doctors and nurses that treat inmates at the jail, and there are tests for whatever she has. Their blood tests, their COVID tests. So they can figure out pretty quickly if she's faking, I think. Is she going to go on a hunger strike next? I don't know. I wouldn't put it past her. Little one, Darrell Brooks. Did he claim it or was he actually sick? I don't remember that. I just remember him being totally out of control in court. But he also represented himself. So let's take a look. Good question. Very good question. They have not come down yet. They have not posted. But that does remind me, Susie. That does remind me. He did the very last thing that he did after he recessed, even like the court had been recessed. He says, court is in recess. We're in recess, whatever. He went down and handed out draft copies of the motions to both legal teams. So if they were draft copies, they haven't been signed and sealed, and they aren't going to be uploaded into the court system for a little while. Sometimes it's a couple of days. These will probably come down a little faster than that because in a couple of days, trial's supposed to start. So as of 5 minutes before I started this live, they hadn't been posted on the court docket yet, but I've been checking literally like every half hour, except for the last half hour when I've been spending time with you and you with me and talking about Lori crapping her pants. Oh my gosh. Yes, maybe her jailhouse baloney turned green, right? I think it was already green. I've heard about green jail baloney, and yeah. Ooh. Boop, boop, boop. All right. Let's take a look at the 2 minute entries that came down this morning. Have the PDFs. All right. So this is Judge Bereski's first minute entry where he is assigning the case to another judge. And this is probably the right thing to do. I mean, he could have made the ruling on the motion himself, but it probably like clears the air a little bit and leaves out the possibility of an appeal, an additional appellate issue, sending it to Judge Green. So minute entry, complex case. Lori Daybell, prisoner number G062213. By the way, if you want to send her mail or money, that's actually a 4062213 is her Maricopa County inmate number. I don't think anybody in here is going to do that. And I didn't do it. I don't know that because I did it. I just know that because I did my research. It is ordered treating the defendant's motion as a motion for change of judge. So in other words, she labeled her motion wrong. Should be a motion for a change of judge. It is further ordered deferring the defendant's motion to Judge Green for ruling. So Judge Bresky said, all right, I'm not going to rule on this. It's a motion that affects me. So let's just let another judge in Maricopa Superior Court handle it. Hey there, welcome in, new people, welcome in. Thank you for joining. I'm flying solo tonight. It's just me and my story and a couple of documents from court, but I do want to go back and look at the videos from yesterday again too, because I think last night when Kresh and I were on together, I don't know that we were able to hear it very well. Oh, that's right. Yes, Trace, you're right. Yeah, I asked Lauren from Hidden True Crime, did you get in there for yesterday morning's motion or yesterday morning's hearing in Judge Green's office? And she said, no, none of us knew about it. None of us were told beforehand. And it was a quick hearing. It was like 11 minutes. So she said that the PIO, Public Information Officer Vincent, felt bad about it. So he emailed them all copies of the video, which is why I don't understand. And she said they were good quality video. So I don't understand why East Idaho and Fox 10's versions of them have blurry video. I did like a 10 minutes worth of searching before this live to see if I could find a better one. I couldn't, but I did find one with better audio from Fox 10. So that's one we're going to look at after this. Yeah, but no media got into the Judge Green's hearing yesterday. So this is what went on in Judge. No, actually, this didn't go on in Judge. This is before the hearing. This isn't after the hearing. So this doesn't discuss what went on in the hearing. I thought it did when I first downloaded it, but it's an oral argument set for a complex case. So it's a setting for that hearing that happened yesterday morning. The court has received the defendant's motion to disqualify the judge, which is treated as a motion for change of judge, filed May 25th, and the state's response thereto, filed May 26th, which we've been over on lives before. It is ordered setting oral argument for May 29th, that's yesterday morning, 9:30 a.m., before the Honorable Jennifer Green. Judge Green's division is located in the South Court Tower, 5th floor, Courtroom 5A. And nobody knew about it. They were all sitting down outside of Courtroom 5D, which is Lori's courtroom. It's not Judge Bresky's usual courtroom, but it is the one set for this trial and for the last trial. So they were literally sitting in the waiting seats, like just 75 feet away from the courtroom where it was held for virtual appearances before Honorable Judge Green, blah, 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 remote proceedings. So this is just standard stuff, setting up the hearing. And this was not released until this, or wasn't posted on the docket until this morning. So nobody knew about it. Nobody knew about it. Hey, Diane, welcome in. Good to see you. Oh, Nina. Yeah, well, I'm glad you can type now. Rest in peace, Loretta Swit. That's what a lot of people are speculating. I'm not going to speculate that. I'm not going to say what I think. I think it could be either way. It could be her faking, or it could be her really being sick. I mean, she's in a jail, one of the most crowded, largest jails in the country, with lots and lots of inmates. So lots of chances for cross-contamination, for catching something. Lots and lots of opportunities for that, which is why they have quarantine. But what's really interesting about Judge specifically mentioning quarantine in jail, I understand that people get quarantined in jail all the time. It happens. He didn't say that in front of the jury. He said that after the jury left. But it's really odd that he specifically mentioned that word in regards to her. So we're going to take a look at that trial on Fox 10, and we'll be able to hear it better tonight than we did last night. But the video is still blurry, and I don't understand, because Lauren said the video she got was really good quality. And another thing to note is this is the courtroom cameras recording. There are 3 different cameras with 3 different angles, and we have front-facing cameras in this. So Lauren made a really good point, and she says, why can't we have that in this trial? Because all we get to see all trial is the back of her head. But look at this. I mean, as blurry as it is, we get to see Trina K, we get to see the judge, we get to see the defendant and her team. There's no pictures of the jury box. Like, so Lauren's like, maybe Court TV screwed it up for all of us, because maybe the court would stream this if Court TV hadn't been granted the right to run the pool camera, the media pool camera. Just a thought. Just a thought. I know Kresha has requested me to try and see if there's any way we can get front-facing cameras in the trial so we can see her and not just the back of her head. I don't know. I don't have an answer to that. All right, but we'll watch and listen to this again. This is her hearing in front of Judge Green for a new judge to toss out Judge Boreski.
Good morning, everyone. The court calls CR 2022-00124201. This is State versus Lori Vallow. Appearances, please.
Trina K on behalf of the state, and for the record, the victim is appearing virtually.
Thank you.
Lori Vallow for the defense. Pamela Hicks, advisory counsel.
Thank you. This got set very quickly. There was a media request that I became aware of in passing, literally on my way over here. I don't have a written request. I have not read all my email because I've been on the bench this morning. Do you want to make a record with regards to the media request from the state?
No, Your Honor.
Okay, from the defense?
No.
Okay. I don't see anyone here. I thought we would address it on the record, but I don't see anyone present from the media. Okay, if there's, I assume there's no objection if they come in. Ms. K.
There's no media in the courtroom because they didn't know what was going on because you hadn't posted it or notified anybody. Otherwise, they were just sitting just around the corner, down past the bathrooms.
No, Your Honor.
Ms. Daybell.
I always object to them, yes.
Oh, you object to them?
Always.
Okay. Is there anything you wanted to put on the record?
No.
All right. My thought is if they come in, we can address it. All right. The court's, this is the oral argument on Ms. Daybell's motion for change of judge for cause. The court's in receipt of and has reviewed motion to disqualify judge. This was filed on May 20th, and the state's response to defendant's motion to disqualify judge. Ms. Daybell, I've read your motion. In summary, the way I read it, you're asking for the court to remove Judge Boreski for cause under Rule 10.1. You cite several reasons, specifically that he's denied various motions.
I'm going to have to look into that. I don't remember that. I don't remember her saying specifically, I don't want my face shown. I don't remember that. I'm gonna have to go back and look at the minute entries from those particular hearings. I think that was back in January. No, that was March. That was the March hearings when we heard the media requests and her response to the media requests. That was also when when Court TV requested to be the pool feed for all media cameras, and that was granted. But I don't remember that specifically. That's a good thought. I'm gonna have to research that. Thank you.
You mentioned facial expressions. You mentioned a belt and his not allowing you to remove it. You assert that he violated your speedy trial. There's a mention of religious persecution and an allegation of personal bias. So you're going to get, and then the state's response is that simply the defendant does not establish judicial bias, appearance of bias, or fundamental error. Of course, under Rule 10.1, the court is evaluating whether or not Judge Boreski can be fair and impartial and whether he can conduct a fair and impartial trial in this matter. So I'm aware of the allegations. You'll have the opportunity to go first, then I'll allow the state and to address the court, and then you'll have the last word. Whenever you're ready, Ms. Daybell.
Okay. I did file this motion in this.
I'm sorry, can you pull the microphone? I'm sorry, I can hear you.
Sorry. I did file this motion in this affidavit after several attempts to, I made an oral motion with Judge Boreski and asked him to recuse himself because of the bias and prejudice that I had seen during our last trial and throughout the whole entire time that he has been the judge over all of these cases. And he refused to do so. So I thought I needed to put it in writing and put all my points in that I felt like were causing him to be biased and prejudiced against me, and that obviously you've read it, so you've seen all the different things that I put. There was an actual comment during trial when I was cross-examining one of the witnesses where he said to me directly after an objection from this state that I was comparing myself to biblical prophets, which I absolutely was not doing.
She has that petulant teenager. Look at Trina K over there, like studiously ignoring her. She's like, everybody's done with this girl. Everybody's done with this girl. But she raises her voice like a petulant teenager. I absolutely was not doing that. Totally was not doing that. We'll listen to that part again, because that's all I hear is a petulant Valley Girl teenager.
After an objection from this state that I was comparing myself to biblical prophets, which I absolutely was not doing. And I didn't even realize it until someone showed it to me on the FTR afterwards that he had even said that, because I was in the middle of questioning the witness. And so there's several times that he made comments directly to me. I tried to address this with him directly in our last hearing on May 14th, where I asked him why he had denied every single motion that I had ever filed in the last year and a half. And he said that my motions had no merit. I asked him if my prior defense team, that he denied all of their motions, that they had no merit as well. And then I asked him, my prior defense team before that, all the motions they filed were denied, and did they have no merit at all either?
Girl, all of your motions were not denied. A few of them, as we have seen, and as Judge Boreski reminded you of, have been granted. Like, he listed them individually, specifically, and then he also listed some that he denied, specifically saying they didn't have legal merit. And then yes, Dizzy, we need sound bites. We need the sound bite of him saying, I believe I was sitting here 15 minutes ago when I granted one. And he granted, that was the one for her to meet with her advisory or with her team during breaks.
Either. And I asked him again if he would recuse himself from this case so that I could get a judge that was impartial and fair and have a fair trial. That is my right, my 6th Amendment right and my 14th Amendment right to have a fair trial, an impartial trial, and not a judge who has some kind of bias against me.
All right. Anything else? Thank you.
Complete silence. Anything else? Complete silence. Oh my gosh.
It's just the prior defense motions almost all exclusively dealt with motions to preclude the media. Judge Boreski applied the appropriate law in finding that the media had a right to be present and tried to limit it by saying things like they couldn't focus on the defendant's papers or things like that to mitigate any of the concerns by the defendant. All of the defendant's motions that she has filed have been without legal basis. They've been appropriately ruled on, and the state's motions set the state as one have been ruled on based upon, again, legal basis. So the fact, as the court is well aware, that the defendant has had all of the motions ruled against has no basis for bias if they're all been ruled on based upon the rules of law and the rules of evidence. So we see nothing that the defendant has provided here that would rise to a level to preclude or recuse Judge Boreski from this case.
Thank you. Ms. Dabo, you can have the last word.
Yes, also, along those lines, Your Honor, that's one thing that I asked Judge Boreski is that he has denied all these motions with no finding of fact and no conclusion of law. I said, what is the finding of fact and conclusion of law? These are just denied, 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 denied. He's also denied several attempts for me to try to ask the state for discovery that.
Okay, hold on. We got to bring Squeegee up to date here. So, short, brief, quick rundown. There was a jury selectus interruptus right after lunch today. So they brought the jury in, seated them. They let the public and the media come in and sit down. And then Judge Boreski, like right away, says, "Okay, we're not going to have jury selection completed today." Didn't give any reason for it. He just said like unforeseen circumstances. Asked the jury how many of them can't come back Monday. 13 of them raised their placard, and he's like, after they left, he told Trina K, he's like, I don't remember the exact word he used, but he was frustrated with people not putting their hardships on their original jury questionnaires because like juror 67 or 60 or no 87, juror 87 was sitting almost directly in front of me. And she had some type of a hardship that she knew about when she filled out her questionnaire. I think, it was unrefundable plane tickets. And the judge is like, did you know that when you filled out your questionnaire? And she's like, yeah, but I didn't know if it was really a hardship or not. And then he dismisses the jury out. They let those 13 jurors go that have some type of a hardship. And then right before he recesses court, he says to Lori, I understand that quarantining happens in jail. So if you can't make it, if you don't think you're going to be able to make it to court on Monday, I need you to tell your team as soon as possible. So all kinds of speculation now about what's going on with Lori. Is she sick? Is she faking it? Anyway, that's the quick, brief update, synopsis of my first 45 minutes, 50 minutes of this. Now we're going over the two hearings that happened yesterday. This is the first one that happened in front of Judge Green, a motion for a new judge. And that's why Boreski handed it off to Green, because he didn't want to rule on that motion himself. So Lori's made her arguments. The state's made their arguments. She's making her counter arguments. And not all that successfully, I would guess. Well, we know the results already. So yeah, not all that successfully.
In fact, in conclusion of law, these are just denied, 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 denied. He's also denied several attempts for me to try to ask the state for discovery that he's just denied outright. And then as I keep filing more and more, as I find out what we don't have and I ask for it, I'm continually, even to last week, getting brand new discovery with brand new Bates numbers, stuff that they realized they never even had before that hadn't been turned over. And I've been asking Judge Boreski for these items for 1.5 years. And I'm getting them 1 week before trial. We start picking our jury today. We're supposed to be doing our strikes today. And along those lines, I had this motion about the RAC belt that I had asked him about since we went through this whole trial, and there was times when the belt didn't fit around me, so it fell
Girl, he already ruled on your rack belt motion. He ruled on that already. And just because he didn't rule in your favor, oh, Squeegee, I didn't even answer your question. Does court start Monday? That was your original question. I went back and explained what happened today and then said what's going to happen Monday. So Monday morning, jurors are supposed to come in at like 10:15. Court will start at 10:30. Then they'll do the stuff they didn't get to today, which is the group voir dire and then the individual voir dire, and then seating the jury of 16, 12 plus 4. And if that happens by 3:00 Monday afternoon, we will have opening statements. Everything that happens before opening statements will not be televised, will not be broadcast at all, because it's got lots of jurors' personal information on it, plus would show potential jurors also. So if they have opening statements, it will be at the end of the day on Monday. I suspect we will. And last time Trina K, I think, went almost exactly an hour in her opening statements, I think, if I remember right. And Lori went 15 minutes, almost exactly.
Fell out of my clothing. We had to stop trial and I had to go fix it. And that is what MCSO recommended, that if that was too burdensome, that they would put an armed guard in the back. And because of the media that Judge Boreski has let into every single one of the hearings and the trial, that they already have an armed guard back there. So it wasn't going to cost the state any more money. It wasn't going to cost anything if he just had them remove the belt and went over the security that the MCSO actually recommended. Every single thing that I asked for has been denied. I feel like he does have a personal bias against me. And all I'm asking for, I went through a whole trial with him, even thinking he was biased against me before the trial started. I filed for a new motion.
Wait, what? Thinking he was biased against me before the trial even started. Thinking. You can't just have a feeling about if somebody's biased against you because they don't rule in your favor. Wow, she is unreal. Before the trial even started, he was biased against me.
Because it came to our attention through the media. The media sent Judge Boreski a clip of one of the jurors saying that he found out about my prior convictions beforehand, before his deliberations. And this is the same exact juror who was brought in twice during trial by Judge Boreski, where he had to admonish him for, one, being on his phone, and two, talking to one of the other jurors about the case. And now he's saying, well, he went on another media thing and said that he took it back. He took back what he said. So I'm not going to give you a new trial. And
oh gosh, I missed that last night about juror 15. My favorite. I was looking through the juror pool today. I'm like, who's my juror 15 in this pool? And I honestly found one, and I'm not going to talk about it now because if he doesn't end up on the jury, and he was like towards the end of it, so he's probably not going to end up on the jury. But I could pick him out of the crowd. I know which one I've got my eye on to start this one.
Well, he went on another media thing and said that he took it back. He took back what he said. So I'm not going to give you a new trial, and nothing was done about it. He refused to call them in and have a hearing and put him on the stand under oath and ask him if he found out this information prior to deliberations. It was very confusing, and everything is just outright denied. I want to go to trial. I want to have a fair trial, as fair as possible. I don't feel like I can do that with Judge Boreski, and I would like to be appointed a new judge who wouldn't know anything about the case and be fair and as impartial as possible. Thank you.
Thank you. I've considered the written motion and the response, and certainly your comments today from both sides. Ms. Daybell, I find that the fact that you disagree with Judge Boreski's substantive legal rulings is not a valid basis under Rule 10.1 to grant your motion and give you a new judge. The standard in 10.1 is, has he demonstrated he can't be fair and impartial? And the fact that his rulings have not gone your way is not a valid basis to suggest that he can't be fair and impartial.
Wait, let's play that again, because maybe she'll hear it now somewhere in the nethers. Just the fact that you he didn't rule your way doesn't mean that he's not fair and impartial. Got to hear that again for Lori in the back.
One, to grant your motion and give you a new judge. The standard in 10.1 is, has he demonstrated he can't be fair and impartial? And the fact that his rulings have not gone your way is not a valid basis to suggest that he can't be fair and impartial. Unless there's some other allegation of bias that's been demonstrated, I don't find on this record that it has been demonstrated. I certainly understand your frustration with the way that the rulings have come out, and it sounds like the way that they came out with prior counsel. But the things that you have cycled through at length in your motion to disqualify, I've considered all of them. Whether or not he should have ruled differently, for example, the example you gave with the juror, or with making findings of fact and conclusions of law in writing, some of the issues you have, if you have concerns about his substantive legal rulings, you can file a motion to reconsider, or you can take them up on appeal. You can file a special action. You have a number of legal remedies at your disposal where you can make those arguments, but they're not grounds under Rule 10.1 to get a new judge. So I am going to deny your motion. Again, as for your concern about his substantive legal rulings, you can address those concerns in a different way, but it would not be under a 10.1. And on this record, I don't find that he's demonstrated that he can't be fair and that he can't be impartial. I also wanted to address the comment that he made that you illustrated. That comment alone doesn't demonstrate that he can't be fair and impartial. I'm not exactly sure of the context where he made it, but it sounds like he let you ask a question with regards to religion, and that was his decision. But again, I don't think even that demonstrates that he can't be fair or impartial in this case. All right, so I'm denying the request to disqualify Judge Boreski under Rule 10.1. Is there anything else from the state?
No, Your Honor.
Anything else, Ms. Abel?
Nope.
Thank you, we are adjourned.
Nope.
Observation
Nope.
phase from
Hold
my
on.
understanding
Dude.
that
All right, so this is 22 minutes of the following hearing that was actually back in front of Judge Boreski. And this was supposed to be reviewing juror questionnaires. And gosh, why are we looking right at the defense's laptop, right in front of the Fox 10 camera? Fox 10 camera was there in Judge Boreski's regular courtroom, 1104 in the main building of Maricopa Superior Court. It's a much, much smaller courtroom. And the security guard this morning told me, well, they sprung this on us having jury selection today in this courtroom 5D, which is the big one that we're all in. It's huge. It was supposed to be in his regular courtroom, and there's no way they could have held jury selection there because they have 68 jurors in the pool. They had 66 they knew of at the time, and new people walk-ins coming in. There are 16 juror seats, I think, and there are something like 30 seats in the gallery. So they couldn't even fit the jury in there in its entirety, let alone the media and the public. So I'm not sure why it was a surprise to him. Obviously some type of internal miscommunication within, the Maricopa Superior Court. But this is the second part. And I remember watching Justin's Twitter feed yesterday saying this was getting kind of spicy. And he said, we're going to start rolling now. But I have a problem with us seeing the defense's laptop right there, because I'm pretty sure she might be looking at juror questionnaire results. And yeah, it's blurry. I don't think we can get anything from that, but what if we could? Yeah, I got a problem with that. And one of the very first motion or hearings that I went to in his courtroom, so had to have been last December 6th, he saw the court camera guy. It wasn't Court TV, it was Fox 10 camera guy setting up right where he is now, in that little corner in front of the gallery to the left side. And he had a little talk with him before he put his robes on. He said, hey, let's make sure we don't show any of the stuff on the defense's table. And we see stuff on the defense's table in this courtroom all the time. I don't think anybody has ever been able to glean any information from it. So Maybe I'm just barking up the wrong tree, whistling Dixie, whatever, but kind of have a problem with that. All right, we're going to keep rolling on this. This is the second motion. This is 22 minutes of Fox 10 coverage of the second motion.
Aggravation phase, from my understanding,
Oh, yeah, the aggravation
that
phase.
we did over my objection last time.
Well, we actually didn't do an aggravation phase.
Well, I
Admitted-
stipulated to it.
You stipulated to it.
Correct. But in adding it to, at the end of trial, a whole guilt phase for aggravators, my understanding is that in January, the state filed their motion, the state's allegation of aggravating circumstances, right? And then my understanding is that that can be brought to the jury during guilt phase. And so, but it hasn't been brought to them yet because it's after the indictment. So it needs to have probable cause hearing, which is the 13.5 hearing. So we need to have a probable cause hearing so that we can add that to the guilt phase. And that's something that gets taken to the jury after probable cause has been found for these aggravators that are alleged.
I think you're referring to the rules for capital cases when there's aggravators filed in death penalty cases.
Correct.
You're entitled to a probable cause hearing, depending on the aggravator. This is not a capital case.
I know it's not a capital case. And in normal capital cases, you don't have an aggravation phase either, right? Only in a capital case.
Actually, you have a guilt phase, and then you have a mitigation aggravation phase.
Actually, have a guilt phase and aggravation phase.
What even Lori cannot lawyer. Like, she doesn't know, but like, I'm just an everyday Joe Schmo. And yes, I watch a lot of trials and a lot of true crime stuff. And I know, but I know this, that she doesn't know. And remember back on December 5th, no, it was December 6th. December 6th was the hearing where the judge granted her the right to represent herself. Go pro per. In Arizona, it's pro per, not pro se. And she was like, well, I've been through several trials already. I don't remember how many she said, and different legal things. And I've been studying law in jail or in prison for the last 5 years. So I'm totally qualified. And she's not. She's only qualified to wear that orange jumpsuit kind of off the shoulder. See how she's wearing that a little off the shoulder? She's like, I'm so pretty. See my shoulder? She's showing a little shoulder there. And it's not it's not seducing Judge Boreski. He's not distracted by her bare shoulder there. Isn't that weird though? Isn't that weird?
Phase and a penalty phase.
Right.
If the aggravators aren't found as a completely separate independent hearing, then there's no penalty phase.
So with the statute for this charge only being the one statute, what are you getting out of the aggravation phase? I don't understand.
Well, first of all, the jury in the initial phase doesn't determine whether or not it's a dangerous felony, which they need to find. And then the aggravators, I think the state has a right to attempt to prove those to the jury, to offset any mitigation or to be weighed against mitigation at your sentencing.
And isn't that normally put together with the guilt phase? Like they would have that on the back page where it says the aggravators and the guilt?
No.
So are we going to have a whole nother aggravator phase in this case?
If the jury finds you guilty of the charge and the state wants to proceed with aggravators, yes.
And so we do not have to have a hearing to determine if there's probable cause for these aggravators?
No,
They're just alleged aggravators.
correct,
And the grand jury never found probable cause for them.
correct.
So you're saying that if the guilt phase goes through and they find you guilty, then you have an aggravator phase added to that.
That's what I said.
Okay. Hold on one second.
She just told the judge to hold on 1 second. She didn't just say, can I have a second? She said, she told the judge, hold on 1 second.
You have the allegation of aggravating.
Okay.
It was on my desk.
Your Honor, I would just like it to be on the record clear that the Rule 13.5 that I'm talking about is about non-capital cases. I know in capital cases, they call it a Cronus hearing, but this is for non-capital case.
Wait. What? Hold on. I'm looking at that strap showing on her shoulder because I commented on the off the shoulder thing before. Like, that's an interesting color. Like, is that prison issue undergarments? It's definitely not LDS undergarments, but she's probably, has she been excommunicated by now? Does anybody know? Anyone? Bueller? I know somebody in chat knows. So do our religious freedoms allow us to wear religious garments, as in the LDS wearing garments, while they're in jail and prison? It's an interesting side thought I just had. No idea.
Well, it says under 13.5A, a defendant may challenge the legal sufficiency of the state's allegations by filing a motion under Rule 16. Is that what you're talking about?
Correct.
It doesn't say you get a probable cause hearing regarding the aggravators.
Well, I'm challenging the state's allegation of aggravators by asking for a 13.5 hearing on it.
That's Abernathy that's whispering in her ear. So he's kind of like Abernathy is kind of like having to make an oral argument through her left ear into the microphone through her mouth. That's got to be extremely frustrating for him, because he probably could have made this argument in like 2 minutes, and then the judge could be like, denied again. But nope, she's got to represent herself. So he's got to whisper in her ear, and then she's got to try and say what his argument is for herself.
So the state's aggravators that they've alleged is that the offense involved the infliction or threatened infliction of serious physical injury. The offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of the crime, specifically a gun. The offense involved the presence of an accomplice. The offense caused physical, emotional, or financial harm to the victim, or if the victim died as a result of the conduct of the defendant, caused emotional or financial harm to the victim's family. The next one is the defendant was previously convicted of a felony within the 10 years immediately preceding the date of the offense. This one's really not very specific. Any other factor that is relevant to the defendant's character or background. So if you were found guilty by a jury of conspiracy to commit first-degree murder, which of these aggravators do you think there's not legal sufficiency for a jury to determine? Because they seem pretty inherent in the charge itself, except for your prior convictions, which, are you saying you don't have the prior convictions within 10 years?
No, I'm not saying that. Which of them don't qualify for the jury to make that determination?
No, you're asking for me to make a determination that there's a legal sufficiency for them to go to the jury.
Correct.
So I'm asking you, if you were found guilty by a jury of the charged offense, which of those aggravators that have been alleged by the state do you think there would not be legal sufficiency for? Because as I look at those aggravators, most of them are inherent in what you're being found guilty of. Again, if the jury found you guilty, for example, the first aggravator, it involved the infliction or threatened infliction of serious physical injury. The allegation is someone shot at the victim. That's the threatened infliction of serious physical injury. So it seems like that allegation, there's sufficient evidence for a jury to decide whether that's an aggravator. The next one, the offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of a crime. Again, if you were found guilty of the charge, as the state has alleged, the jury would find that a gun was used. So that's a separate aggravator, again, that would already be determined by the evidence. The state has alleged an accomplice, your brother. If the jury were to find you guilty as charged, again, my understanding of the state's allegation is your brother attempted to shoot Mr. Boudreaux. You weren't in Arizona. So if the jury found you guilty of this charge, it would mean they found you guilty as an accomplice. If someone shot at, the next aggravator, I don't think it's a leap for a jury to presume there's some sort of emotional harm. So I'm struggling with what
We're all
legal
struggling.
sufficiency you think is lacking for a jury to make those determinations. Again, only if the jury found you guilty of the charge.
He's trying to get into her head, and he's also trying to give her legal advice and also trying to make a fair and impartial ruling. But I'm trying to figure out, I got to go back and hear that one more time. Trying to understand. That's what it was. I'm trying to understand.
Shot at, the next aggravator, I don't think it's a leap for a jury to presume there's some sort of emotional harm. So I'm struggling with what legal sufficiency you think is lacking for a jury to make those determinations. Again, only if the jury found you guilty of the charge that you're charged with.
I understand, Your Honor, but in 13.5,
No, you don't.
whether capital or non-capital,
No, you
the
don't.
state has the burden to establish probable cause, the legal sufficiency of an amended indictment. This is an amendment. This didn't go to the grand jury. Is that correct?
Right.
So now I have the right to ask for a hearing so the probable cause can be found for these aggravators ahead of time.
So you're confusing two things.
Okay.
All right. 13.5B talks about amending the charge or the indictment.
Mhm.
Okay. Your charge is conspiracy to commit first degree murder. It's not, your charge is not being amended. The grand jury did find probable cause for that charge.
Correct.
An aggravator is not an amendment to the indictment.
It's a whole nother allegation. It's a whole separate allegation.
Difference between an aggravator and changing the charge that you're charged with. If the state were to change the charge that you're charged with, for example, if they changed it from conspiracy to commit first degree murder to conspiracy to commit second degree murder, there'd probably need to be a new probable cause.
Correct.
Secondly, as to the allegation that it's a dangerous offense, the grand jury did make that finding because that allegation was included in the indictment that it was a dangerous offense. So there has been.
So the aggravators are not a criminal act. The aggravators were defined by the Arizona state legislature, and the governor, signed the bill, saying that if you commit a serious crime like a felony here, your sentence can be enhanced because you also, at the time of committing that crime, you also did other things that are bad, like using a gun, like endangering somebody's life. Those are aggravators that can enhance your sentence and make your sentence higher than if you just committed conspiracy to commit first degree murder of somebody and there was no gun involved, there was nobody's life that was in danger, like whatever all the other aggravating factors are. So your sentence would be the base sentence if there weren't any aggravating factors, but that's determined by the legislature, not by a grand jury. So she can't even see that division, and that's what he's trying to explain to her, and she's just not getting it.
There has been probable cause as to the dangerous factor.
Okay, if that is the case, then why isn't that found in the original guilt phase as opposed to having a whole nother aggravation phase after that, as if it's a capital offense? Because there's one statute,
Well,
there's one sentence, there's no arguing the sentence, and if it's already a dangerous crime, then there's no reason to have an aggravator phase.
What do you mean there's no arguing and there's one sentence? I don't understand what you're saying.
There's one sentence for the charge. There's only one sentence for this charge. And if it's already classified as a dangerous charge is what you're telling me, right?
No, there's not one sentence. There's 25 to life. So there's a minimum and a maximum, and aggravating factors can take that above the minimum towards the maximum up to the maximum. So that, I mean, I don't know how the judge is going to get this through to her because she's just not getting it.
Right, because it's conspiracy to commit first-degree murder. That's a dangerous charge. The jury has already found that it's a dangerous charge. Then what is the aggravator phase finding? If it's already a dangerous charge and there's only one sentence.
No, there's a minimum and
Does the state
maximum.
want to respond why the state wants to proceed with aggravators?
To start with, the jury is not going to make a finding of dangerousness as part of the guilt phase per case law. That's not permitted. So the jury has to make a separate independent finding after they find the defendant guilty. The dangerous finding will include the use of a weapon and or the
this is my favorite view of Trina K. Eyes closed, frustrated. She's like, ugh. It's like a physics teacher trying to teach a sixth grader about Newton's laws of physics. Like, they're just not going to get it for the most part. I mean, they can understand an apple dropping on your head, gravitation, like they can get that part of it, but like equal and opposite forces and all that are going to be clasping your hands, closing your eyes. Deep sighs, lots of deep sighs for Trina K.
or the intentional infliction of or threatened infliction of physical injury. So at the very least, the jury has to make a finding as to dangerousness.
I agree about dangerousness. I guess the question is, why does the state want to prove up aggravators if the jury finds the defendant guilty of the charge as a dangerous offense, given the sentence?
Your Honor, in all honesty, you could ask me this, 10 years ago before Blakely was put out. As case law changes on appeals, I've had to come back before and redo a penalty phase, an aggravation phase, and re-impanel a jury. So I prefer to, since we're already going to have an aggravation phase for the dangerous allegation, to add on the other factors, and therefore I don't have to ever worry about this coming back on appeal later.
All right.
How is it not already found to be dangerous? You just said that if they find me guilty, then it will be dangerous.
I didn't say that. I said if they find you guilty, then they make a determination whether or not it's dangerous. Now, I think what I meant was when a crime involving a weapon is used, whether it's a gun, usually it's sort of a foregone conclusion that if the jury found you guilty of conspiracy to commit first-degree murder by someone shooting at another individual, that they're 99.9% likely to find that it was a dangerous offense. But it's something the jury has to do.
Right, but usually aren't aggravators for sentencing? What other purpose does it serve in this case with this charge, with one statute? You can't give me less time, you can't give me more time, you can't do anything else except for, it's one statute.
I guess the prosecutor's saying she wants to cover her bases in case there's some change in the law and what a jury has to find or not find for purposes of sentencing. And they have the right to proceed with aggravators. All right, you're right in that if you're found guilty of this charge at this level, you get one sentence. But who knows what a court of appeals would do in the future if aggravators or things weren't presented. I don't know that what would be presented at a sentencing phase from your side or from the state's side, but it sounds like the prosecutor's wanting to cover her bases.
So then I'm not entitled to a hearing before trial starts to find probable cause for these aggravators that were not taken to the grand jury initially?
Madly in love with Jesus. You know what? I struggle with that thought all the time. And I also struggle with the thought. So madly in love with Jesus says she sounds like she doesn't want to understand. She wants to argue. And there is absolutely some of that going on. There absolutely is. She refuses to take no for an answer. Like the typical narcissist, she refuses to take no for an answer. But also, I honestly believe there are some comprehension issues going on with her. I really do. I don't think she's as smart as she thinks she is by any stretch of the imagination. But I do struggle with that thought and balancing it with how much does she really not understand and how much does she not want to understand. Judge Bresky is going to be ready to move on after this is over.
Really?
All right,
I'm asking.
I'm trying to explain it to you. The jury did find probable cause that this was a dangerous offense. It's included in your indictment. So they did find.
They didn't find these specific aggravators being a dangerous offense, and these specific
Can I finish
aggravators
what I said,
are different,
what I was saying?
right?
I didn't interrupt you. Can I finish? Okay. The
All
jury
right.
did find probable cause
We're
on
going
the
back to see that
dangerous
again
allegation.
because that's
All
what
right.
everybody's talking about.
You're
So we're
not
gonna watch that
entitled. The
again.
jury did find probable cause that this was a dangerous offense. It's included in your indictment. So they did find.
They didn't find these specific aggravators being a dangerous offense, and these specific
Can I finish
aggravators
what I
are
said,
different,
what I was saying?
right?
I didn't interrupt you. Can I finish?
Oh
Okay.
man, she brings out his raised voice, and it happened a couple of times too on the May 14th hearing. It happened a couple of times in there. That one that went viral that I was in the courtroom for. He raised his voice a couple of times, and then he would immediately back off. But she got him to raise his voice again. This has got to be one of the most infuriating people, and he's got to be regretting allowing her to represent herself. He's got to be regretting it. Oh boy. Listen to him raise his voice to talk over her.
They didn't find these specific aggravators being a dangerous offense, and these specific
Can I finish
aggravators
what I said,
are different,
what I was saying?
right?
I didn't interrupt you. Can I finish?
I didn't interrupt you.
Okay. The jury did find probable cause on the dangerous allegation. All right. You're not entitled to a probable cause hearing on the other aggravators.
When is conspiracy to commit murder not a dangerous crime?
When someone says they're going to choke someone to death and they don't actually do it, it's not a dangerous crime.
But for something to be conspiracy, you can't just talk about it. You can't just say it. You can't just mention it. You have to take some type of action. There has to be a first step of you trying to complete that thing that you're conspiring to do with somebody else. Like you can't just talk about it. You can't just say, hey, let's go rob a bank and then and go home and never do anything about it. Like if you go buy a gun or a mask, I mean, then that's one step towards the conspiracy. So then you can be convicted of conspiracy. So I'm not going to doubt Judge Bresky here, and I'm not going to question what he said, but I don't think he's going to explain it in a way that she understands. But that's actually a good question on her behalf. And if she were any kind of a decent attorney, she might be able to follow up with that. But she's not going to. She's just going to try and push his buttons. That's what this is about. She's trying to push his buttons.
So
No dangerous instrument or deadly weapon was used.
So because some instrument may or may not have been used in this crime, it's considered a dangerous crime?
Right.
And these aggravators that talk about something totally different don't have to be found after that it's found a dangerous crime?
Correct.
And that is supported by case law?
Yes.
So that what? When you go to appeal, you can't say it was a non-dangerous crime?
All right. I don't know what to tell you. All right. There was a case that came out about 15 to 20 years ago now called Blakely that said a jury had to determine aggravating factors. Okay, before that, a judge determined aggravating factors at sentencing. Now a jury has to determine it. The reason it's not done in the guilt phase is we don't want the jury to confuse the issues. We want the jury to decide first whether someone's guilty or not guilty, whether the state has proved its burden beyond a reasonable doubt. We don't want them to start thinking about other things like aggravators if they have questions about whether or not the person's even guilty. It tends to confuse the jury and confuse the issues for them. So that's why we do the aggravators in a separate hearing. First, you want to make sure the state has proved its burden beyond a reasonable doubt as to your charge.
But these specific aggravators that they allege, right, the ones that you just went over, you're saying that now after you're found guilty of a dangerous crime, that they're going to go back in, and what is the purpose of that? How does it change anything after that?
I don't know how else to explain.
I really think her advisory counsel right there, Mr. Abernathy, is regretting telling her that he had an idea about how she could challenge the aggravating factors, because this totally seems like his idea and she's arguing his idea. And I think he's regretting giving her this idea now because he's sitting right next to her and he never does. And Pam Hicks is sitting at the table. In the last hearing in Judge Boreski's courtroom, they didn't. They sat back in the corner underneath the camera so we couldn't see them. But they're both sitting at the defense table right now. So I honestly think this may have been his idea and he's trying to guide her through it. And he just can't argue it for her because he's only advisory counsel. At this point, honestly, at this point in time, she should, especially if she doesn't plan on presenting any evidence or witnesses in this trial for first-degree conspiracy to commit first-degree murder of Brandon Boudreaux, if she doesn't plan on presenting any evidence or witnesses, she should turn it over to her advisory counsel right now. Let him get up here and argue this motion because he's not going to screw it up like she's screwing it up.
Explain it to you. So do you have other issues that you want to bring up today?
Yes.
Oh no.
I would like to finish this first. So are you denying my motion to have a hearing on this?
I'm denying your motion to have a probable cause hearing as to the state's alleged aggravators.
Okay, so you're denying my motion to have a 13.5 hearing on these alleged aggravators
Correct.
before trial starts.
Because you're not entitled to one.
Okay.
13.5 says that you're entitled to a probable cause hearing if they amend or change the indictment.
This is not an amendment of the indictment?
It's not. There's a difference
It's an extension of the indictment. It's not in the indictment.
It's a difference, okay, between an aggravator and changing the charge that you're charged with. Changing the charge that you're charged with is an amendment to the indictment. For example, if you were just charged with conspiracy to commit first-degree murder, all right, but the state didn't allege with the grand jury that it was a dangerous offense, you'd be entitled to a probable cause hearing as to that dangerous allegation because it's changing the charge and it's changing the sentence that you would be getting. These aggravators.
That's exactly my point. After the fact, these aggravators, if they're found, what do they do to change the charge or change the sentence or change anything?
Probably nothing in reality. You just said it. They don't change the charge. So you're not entitled to a probable cause hearing.
Okay, then I don't want to have an aggravation phase either.
Well, you can
How are you entitled to that? And I'm not entitled to a hearing on probable cause, but you're entitled to have an aggravation phase.
Okay. Well, if you don't want to attend, you don't have to attend. What else?
That solves that.
All right.
I want a front-facing camera right there. All right.
Something dealing with trial is that I've asked several times for headsets for my advisory council. I know that's been an issue that you said we can only have 5 headsets. Is there some way we can do that? Because it's very difficult for them to advise me on things when they kind of don't know what's going on.
If you need a break to consult with your advisory council, we can do that. I can only give so many headsets.
You said you were going to check into that. Is that something that you did check into and there's no more available headsets?
They can't do more than 5 on that particular system or network that they have. I need my court reporter to have one so we can do the sidebars. The state's only getting one. I get one, so that leaves 2 for you. Whoever you want to have besides yourself, you can choose one of your advisory council or your paralegal.
This is like the third time he's told her this, and she just won't take no for an answer. But it's kind of like the same thing. Judge Hippler in the Koberger case made a ruling, I think last week, where he said, so if you're watching Karen Reed at all, every time there's a sidebar, they all go up to the judge's bench. Like there's a train of like 10 people that all go up to the judge's bench. Hippler in Koberger case, the Idaho 4, said, we're going to have just the attorney that's examining the witness and one attorney from the other side that's responsible for examining the same witness up here at my bench. We're not going to have a train of 10 people come up for sidebars. They don't have sidebars in Idaho. They only have those in Massachusetts. But anyway, so it's kind of similar to that. Like you have 2 headsets, one for you, your lead counsel, and you can choose to give the other one to one other person, and that's your choice. And that's like if she gave that to Abernathy or she gave that to Pam Hicks. Oh my gosh, look how clear you can see on Pam Hicks' computer. Look at that. I just noticed that. I can't zoom in. Sorry, guys. Tried zooming in. Somebody's going to try and zoom in. That is one of her emails, or official emails. And you can almost see who that email is from. Wow. Somebody's got to put a stop to that. Judge Boreski, like you cannot have that camera sitting right there behind defense table showing that stuff. That's no bueno. Another rabbit hole. Side thought.
But you're forcing me to choose between the people that are helping me?
Sure.
Okay.
Technically, I don't know I even have to do that. You represent yourself. You're considered your own attorney. You don't even have the right, the right to consult. I shouldn't say that. You have the right to consult with them, but it's not a necessary thing. Because you are acting as your own attorney, you're expected to proceed as your own attorney. They don't have an affirmative duty to even give you advice under the case law for being an advisory council. The fact that they do is probably helpful to you, okay? But you chose to represent yourself. It means you are supposed to act as your own lawyer.
You appointed them and assigned them to me. I did not ask for them.
We are watching Pam Hicks read and respond to emails on Fox 10's courtroom camera. I'm blown away. But I'm not surprised that Lori doesn't want her help, and she's not giving her any help. She's conducting public defender business right now. But it's crazy to me. They're showing this.
Okay, yeah, I did, in case you decided not to represent yourself so they could step in at trial.
Okay, well then it's an alternative that we could do sidebars at the bench so that they could be involved during
I
that
think
time.
it depends on the complexity of the question. If it's a simple jury question that, like, for example, can we have a copy of the police report? The answer to that is always no. So I think I'll have to take it on a question by question and issue by issue basis. So if it's an issue where we need everyone at the bench, yes, we can do that. But if it's a simple, quick response that we can do with the headsets, we'll do that.
Okay. I have one more issue.
Go ahead.
Okay.
Oh gosh.
Seeing as how things went in the last.
The verbal subtleties to that little exchange. You have something else? I have one more issue. Okay. Like listen to their voice intonations and just that little verbal exchange between the two of them. Like they're done with each other. Like there's about to be a divorce and a breakup, and who's going to get the kids?
Report, the answer to that is always no. So I think I'll have to take it on a question by question and issue by issue basis. So if it's an issue where we need everyone at the bench, yes, we can do that. But if it's a simple, quick response that we can do with the headsets, we'll do that.
Okay.
Okay.
I have one more issue.
Go ahead.
Okay. seeing as how things went in the last trial, my question is,
Hold on. That is not Jeff White is her investigator, and that's not Lonnie Dworkin. That is, I think his name might be Michael Abernathy. I know his last name is Abernathy. He is co-advisory counsel with Pamela Hicks. That's who that guy is, and who was whispering in her ear earlier. And here we go.
What does the state intend to bring in from Idaho so that I can prepare my questions without being accused by you of opening the door? How can we avoid that when almost every witness has testified in my Idaho trial? And I don't want to be responsible for doing that. So how are we going to handle that?
Well, I will tell the prosecutor to make sure a caution is given to each witness that no matter what the question is, that witness should not think it's a question that would require an answer about prior testimony or prior proceedings. State agrees, right?
Yeah, sure.
I guess they can be further advised that if they think you or the state is asking a question that calls for that sort of answer about prior testimony or a prior proceeding, that maybe we should take a break.
Okay.
All right. Anything else?
That was it.
So there was discussion about that today that I didn't go over earlier because I know we'd bring it up right now. Trina Kay actually was proactive in today's pre-trial hearings right before lunch. She said, so I heard what the defendant said yesterday, and the way that I can handle that is I'm going to have to ask some leading questions. I'm like, oh, no way, Trina Kay asking leading questions? Never. Anyway, so most of this is probably about Brandon's testimony because he knows he saw that Jeep before the day that somebody took a shot at him from out of the back of that Jeep. He knows that he saw that Jeep before. He knows that it was probably Tylee's Jeep, and I think she's going to ask him about that. I'm reading between the lines. Oh no, I held up my hand. My camera almost went off of my face. See, look, move to the left, move to the right. I'm reading between the lines of this little exchange that happened right before lunch. She said, I'm going to have to ask him leading questions about that incident that occurred on July 11th, 2019 in Chandler. And we all know what that incident was, but the jury is supposedly not going to know what that incident was. So she will be able to bring that incident up without referring to it as the day that your brother murdered Charles Vallow, right? That you have been convicted of and will be sentenced for after this trial's over. So she can't bring that in. So she's going to refer to it as that incident. So also Lori pipes up after that and she's like, okay, but what about when it's my turn to ask a witness questions? And they also testified in my Idaho trial. And I want to ask them about their testimony in that trial. And then they pretend to not be able to remember what they testified to in the trial. So she's expecting somebody to say they don't remember how they testified in the trial. And she said, well, first she says before that part, before they can't remember, she says, will I ask them about a prior hearing that was held? And the judge says, no, you asked them about a prior, and the word just escaped me. And it's in my Twitter feed, not procedure, something like that, something like procedure. Don't use the word hearing, proceeding, that's the word. You testified in a prior proceeding. And she says, okay, what if they claim they can't remember how they testified in that prior proceeding? And the judge says, you mean like you want to impeach them? And she says, yeah. And he goes, all right, I got to help you out again. I got to help you out because you don't know how to lawyer, girl. He says, you could hand them a transcript of that prior proceeding, the trial in Idaho, and ask them to refresh their memory. You can't ask them to read from it, but you can ask them to refresh their memory from it. So yeah, he helped her out again. So I was saving that for this.
All right, we'll see everyone.
She said, if all parties is on the jury, that also means that we can bring.
She looked back directly at the, watch this. She looks back and side eyes the camera and does a little smile.
Okay, so
Watch this. Watch her. Oh, she looked directly at the camera. She looked directly at it. She can't help herself.
So
she made eye contact and smiled at Trace today in court. She didn't me. I wasn't looking for that. I'm not looking to get sucked down the portal anytime soon. So that's it. That's the nutshell from what happened today. Let's see. We got one starred comment. Yeah, rude and disrespectful to the judge. Okay, so here's the thing about that. She is only rude and disrespectful to the judge when the jury is not present. She is on her best behavior when the jury is present. She's cute. She uses her little girl voice. Like, she knows when the jury's watching and when they're not. And she doesn't care when the whole rest of the world is watching, right? She doesn't care. She looked directly into that camera yesterday at the end of that hearing. All right, guys, I'm going to wrap it up. It was a short day in court, and it's getting late on a Friday night. Let's see, it's 6:52 Arizona time. That means it's 9:52 East Coast time. I want to thank everybody for jumping into chat and watching. Thank you, everybody, for your comments and your questions. Does anybody have any more questions before we go? There is so much to unpack in this case. I think it's going to go fast, but people speculate like, what is she going to change her behaviors from the first trial to the second? Like, did she learn any lessons? And my gut instinct is no. She doesn't learn lessons. It's all about Lori. She didn't do anything wrong. The judge is just being unfair to her. The jury was unfair to her. Juror number 15 never got called in for an interview with the judge, which I honestly think he probably should have been, but that's beside the point. I'm not the judge or the jury. Yeah. All right. Good night, everybody. Thanks all for all of your comments and questions. Keep an eye out. I'll be going into court and we'll be doing daily recaps with Trial TV Live. I'm going to post their link right now. We're going to co-stream daily trial updates. Monday may be a short one because we may just have opening statements, but we're definitely going to have jury selection on Monday. Trial TV Live. Here we go. See, I can do this by myself. I can fly solo. I believe I can fly. Oh, wait, we don't want to go there. Boop, boop. No, that wasn't the link. That was my... Let's try this again. Maybe I can't fly. All right, we're going to be doing daily recaps throughout the trial on Trial TV Live, co-streams on both channels. Come learn from Pammy, learn how to straddle both at the same time. And we would love to see you there. Trace and I are going to be there bright and early Monday morning for jury selection. Thank you, chat. Thank you, mods. Thank you, Squeegee. Thank you, Trace. We will catch you on another stream in the very near future.
a seat. Grab yourself a cup of joe and put up your feet. Let's talk about the latest news and all about true crime. We can make a difference if we put in the time. Good evening, come and find you a seat. Grab yourself a cup of joe and put up your feet. Let's talk about the latest news and all about true crime. We can make a difference if we put in the time. Oh, we can make a difference if we put in the time. Good evening, come and find you a seat. Grab yourself a cup of joe and put up your feet. Let's talk about the latest news and all about true crime.